PC main number in our Manhattan, New York office, 718-576-1646. Georgia number, 770-222-8240. Of our Caribbean offices, 225-2684 for Guyana and 876-665-3911 for Jamaica. Okay, welcome back. Welcome back. You're on to the Immigration Times, also previously known as Immigration and You. As I was explaining previously, that we have changed the name because it now suits the nature of the situation and the period of time that we're dealing with. Therefore, a lot of our periodicals, are now called the Immigrant Times or Immigration Times. Okay, so we've appropriately named the program as much. Now, as a precursor, fairly soon, or actually on the screen right now, you will see the number that you can call in, and you can ask me any single question that you want. If I don't know it, then I don't know everything. Okay, so I will simply tell you, well, I don't know, but I can research it, or I'll tell you what I do know about it. Subject to finding out a little bit more. Researching your case also helps me gather information and gather strategy with regards to situations. Now, I do apologize that before we jump into the topics, I do apologize if anyone's been trying to reach me in the past 12 to roughly the past 12 months or so. As everyone knows, the station, myself, my family have gone through a bit of circumstances and a bunch of unfortunate events in the last year, but that is now done. It's over with, and we're fine now, and we're recuperating, and we're getting back on track and getting back on stream. Hence, I am now back with you on television. Okay? And my office is open at any time to answer pretty much any question that I can as far as getting your loved ones to the U.S. and preventing them from forcibly, against their will, returning if necessary. So in concert with that, tonight's program is basically about deportation, its procedures, what to look out for. And this is for basically people here who are looking at it. And once this item is published, this video is published on the web, then other people will be able to see what it is that they need to start looking out for. And then what we're going to try and get to and get through is the issue of re-entering the U.S. after deportation. Okay? Now, I do apologize for a bit of the camera work tonight, as this is the first night that we're on. It was kind of rushed. We were seeking for airtime, so we're kind of working things out as we go. But as you can see, if you need to call in and ask for any questions, 223-5192. That's 223-5192. I'm going to repeat what I said before we went to commercial break for those who may not have heard it. If you're going to call and ask me about non-immigrant visa processing, or why you didn't get your visa, or why it is that you were denied, I would basically ask you to refrain, because I can give you an answer. The questions are always the same. Either why was I denied, or what do I need? And the answer to that question, honestly, if you're going to ask me over the air, is I don't know. Okay? And the reason why I said I don't know, each case is very specific. We all go through and we hear everything in the street about this is what you need, and you need to show this, and you need a transport, you need a bank statement, you need a deed to a property, you need a certificate of title, you got to have money in the bank. The response to that is that it's true, and yet it's not true, because you don't know. It's on a case-by-case situation. We all know people who have gotten visas who don't have a house, they don't have a car, they don't own anything. But the critical test to the matter is that it is that you have the intention to return to Guyana. Now, all of those things together can show that you intend to return to Guyana, or a closer look at it can show that you don't have an intent to return to Guyana, or to your country of origin, right? And that's for other people who are not of Guyanese origin, which is where this series is being filmed. Okay, so what you would need to do in order to assess maybe why it is that, especially if you've been denied before, then what you need is an assessment of your situation. That's the first thing that you need to do. Okay, the second thing that you need to do is, in reapplying, you ensure that you have every single thing that you believe that you need in order to be able to get it done. Sometimes it just takes a matter of talking, because the consular officer only knows what it is that she has in front of her, and what he or she has in front of her may simply only be your application and whatever other background information that you have before. So when it is that we are filling out the applications and trying to do trickery and so on, a lot of times it doesn't really help. Okay? And that's basically what it is that I have to say on that. Now, deportation. One of the reasons why I think that this is a critical issue is this. Number one, there's some very, 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 very bright people who have been removed from the U.S., who actually have done their own research, who have fought their own cases, and quite frankly, they've actually impressed me. They've told me things that I didn't know, because it is that of the nature and length and depth of the research that they've been able to do. However, there is one critical issue that always remains, is the procedure. Okay, and normally, which is where, on the first layer of this, I'm going to discuss the procedure, and then I'll see if I can go deeper into the layers of it so that you can kind of get an understanding of what it is that I'm talking about. A lot of people have been removed against their will simply because they didn't know or understand the procedures, or simply because they didn't want to go through the procedure, and they basically signed an order of removal. Okay? Now, my proposition is that I don't think that anyone needs to sign off automatically on an order of removal. The reason being is this. We normally consider, the average individual considers, that, oh, I've committed this crime, I've done my time, and, it doesn't really make sense to deport me. I mean, it doesn't really make sense for me to fight the deportation, because I'm going to get deported anyway, or that there's no defenses to deportation. Normally, when I hear stuff like that, it makes me cringe, and you kind of lose respect for quite a few people. Some people, you just have to let them get deported, because they're actually psychologically not helping themselves and assisting in losing their own case. Now, the average immigration case commences with what we in the legal field colloquially call an NTA. And what an NTA is, a notice to appear. It means that the government sends you something in the mail that is giving you notice that you need to appear at a removal hearing on such and such a day and such a time. Sometimes you may get the listing of the charges on that document that are a bunch of allegations that states why it is that you need to be removed or deported, and then it then states the nature and section of the law, and justifies, in that final section, it then gives the justification based upon the allegations why it is that you need to be removed. Okay? Now, Normally what happens, the average individual who doesn't hire an attorney, either because you have no money to, there may not be legal aid, things are happening too quick, you're depressed, for any number of reasons, or you try to go it alone and try to see if you can figure it out. Now, what normally happens is once you serve the NTA, what a lot of people don't realize is that when you appear in court, the judge asks you, how do you plead? Enter your pleadings. This next step is for you to enter your pleadings. You either agree to allegations 1 through 5 or 1 through 10, and you will either concede or not concede to the ground of deportation. Okay? In most cases, or in a lot of cases, for the cases that we take, we try not to concede if we don't have to. Because not conceding or contesting the ground for deportation, and I'll give you an example in a minute, it means that those things now end up having to be proven. Because if you agree to everything right there and then, your case is already halfway done. Okay? The only thing that you really have left, which is what you're waiting on, is your forms of relief. Okay? And I'm going to get to that. It sounds a little strange, as these are not really procedures that the English Commonwealth is kind of used to, and the terms and these colloquial terms like NTA, order to show cause, pleadings, allegations to pleadings, chargeability, and so on in a document for immigration purposes. So what then happens is that you have to go through each and every allegation, and you need to, and if it's challengeable, you put up your challenge to it. Because at this stage, you can still have a case dismissed. Okay? You can file a motion to dismiss. You can actually, based upon the nature of the charge, you may actually be able to negotiate with the assistant district counsel for dismissal of the case, or to actually withdraw or withhold from prosecuting the case, depending which is what they call exercising prosecutorial discretion. Okay? Now let's say if someone was arrested on a drug charge. Okay? And this is very prevalent actually in Guyana. You get arrested on a drug charge. However, when you get arrested on a drug charge, you end up in court, you do your time, you're transferred to the immigration facility subsequently, or you are appearing during your proceeding while in custody, and you end up receiving an NTA, and the NTA says that you are liable for an aggravated felony. It could be drugs. It could, most popular are drugs and guns. Okay? So let's deal with drugs and guns. Now, let's just say that you end up with charges or allegations, and their summary of the grounds for immigration, or grounds for removal, are based upon the fact that they deem you an aggravated felon. Now, that is the most popular. Sometimes, if you agree to that, and you just say, okay, fine, I'll sign off on it, and yes, Judge, I agree. Now send me home because you don't want to be in custody any longer. What happens is that you've been charged, of which you've consented to, is an aggravated felony. Now, what you need to do is to have your situation analyzed, and if you can't afford an attorney, you may need to be able to find maybe someone from the Catholic Charities or some other free legal aid attorneys to get involved, at least even if to give you an initial assessment, because a lot of those crimes are not in fact aggravated felonies. I mean, a lot are, but I've come across quite a few that are not. Okay, and what happens? The reason why an aggravated felony um, is so serious is because it doesn't really offer you too many defenses, um, or too many forms of relief of removability, with the exception of maybe Convention Against Torture, um, Convention Against Torture, asylum, and maybe withholding of removal, depending upon the time. We have a caller coming in. Let me just take the caller, and hopefully I can remember where I left off. Hello, good evening.
Hi, good evening. I'd like to find out something, but it's not pertaining to the topic you're discussing. Is that okay?
Sure, it's fine.
Okay, my problem is that my visa fee is paid and all the required documents were sent in by my sister. She chose to be my agent. May 1st, she said she sent in the last set of stuff according to her. But I would like to know how long is that sort of thing time takes? How long will that take?
Okay, let me see if I have it, because the volume on the phone is a little low. But you you've designated your sister as your agent in an immigrant processing case, correct?
But she said she would have been the agent. I did not.
Okay, you didn't designate her.
Because my mother, she couldn't handle, she understand this stuff. But my sister, she was, when she more young,
Right.
she was able to do it.
Okay. All right. So now you want to know how long does what process take for your papers to be processed?
Yeah, they say that, they say it takes about 11 weeks.
Right. Okay, well, let's go through this. This is how I would do it. Who filed for you?
My mother,
Your mother. Are you married or unmarried?
I'm married with 3 children.
You're unmarried with 3 children.
Yes.
Okay. When did your mother file the petition for you?
February 23, 2010.
In 2010?
Yes, February 23.
Okay. This is how I normally analyze it in a nutshell. Okay? And I'll give you a resource where you can go to check, to see where they are on your case. Okay? Now, in your category, you are in the category of an unmarried child over the age of 21 of a U.S. citizen. Okay? In that category, you're probably looking at like about a 10-year processing period. If you had asked me this question 10 years ago, the period of time would have probably been like 6 years. But now, as more and more and more people are applying in your category, you have that backlog, which now stretches it out. Because in your category, they only have X amount of visas that they process per year. Thing is, maybe like, it is possible, I think it's like maybe 200 and something thousand for a particular region. Okay? So once they reach that amount, then you got to wait until the next year. If they haven't finished that set, they still have to finish that set first before they go on to the next set. So you're caught in a backlog. So you're probably looking at maybe a total of about 10 years. Now, you said she filed in 2010?
Yes.
Okay. Now, I would probably figure that from the now till the time that you get into the embassy, you should be looking at roughly about anywhere in between 36 to 48 months.
Uh-huh.
Yeah. Because your case is now in the National Visa Center. That's where they appoint the agents and you do the affidavits of support.
Uh-huh. Yeah, they
Right?
did that.
Good. So once all of those documents are in, what then happens is that they have to wait for your visa, wait for a visa number to become available to you. Okay?
Uh-huh.
Now, once a visa number becomes available to you, then they release it from the National Visa Center.
Okay.
Right? Actually, you know what? I would probably say check. You should be what you need. Well, I'll give you the resource in a minute, but you're probably actually looking at. It's probably going to be about 8 to 10 years, right? So probably within the next 12 months, look at it because I don't know what has happened in your case, but you're looking in that 7 to 10 year period.
Well, I'm already, this is the 8th year.
You're already what?
This is the 8th year since it's,
Okay, so you are probably, well then, you're probably within maybe, if this is the 8th year, and I don't know what types of delays there may have been in your case or how effective document production has been.
yeah, that was the problem, Mr. That was it, because you find that when my sister was given the stuff to send it, she delayed,
Right. Well, those
yeah, it's
those are the items, those are the things that take it out of the regular normal processing
okay,
times.
okay.
Right? So I don't know of what's going on in your case. I've never seen any paperwork, but I am averaging, if you are within your 8th year, I would probably say your case, you should be hopefully in the embassy maybe around the next 24 months or so.
Okay, because they sent me an email saying that they got all the documents, but
Yeah,
I
they're going to
have to
have
wait.
everything,
I
and
have
they're
to
processing
wait.
it and packaging it.
I have to wait because they're not sure if you have to get anything else, so they can't really say.
They will send you a
exactly.
checklist,
Okay.
okay, and let you know if there's anything that needs to be updated, if there's anything that's missing. They will let you know when your package is sent to the embassy. They will let you know everything, and you will get a letter stating that we're in final processing of your case, that a visa number has become available to you.
Okay.
Blah 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 blah.
Okay.
Okay? Now, finally, what you can do is, and this is for anyone out there, if you want to know where your case is, and based upon your priority date, so that you especially you know when your priority date becomes current. Once your priority date becomes current, more than likely a visa number is going to become available to you. When that visa number becomes available to you, that's when all the things begin to happen.
Okay.
Okay? So you can go to the National Visa Bulletin.
Okay, national visa.
Okay, and that has the whole list of all of the categories. You look for your category, and then you look over to see, you can actually see where they're processing on a day-to-day basis.
Okay.
The only thing is, if you're an impatient person, it might run you mad. Right? So you have to have strong constitution in order to look at it, because you're going to look at it, you're going to get frustrated and say this thing is not moving, it's not going. Sometimes for 2-3 months you don't see a change.
Okay.
Okay, but then all of a sudden it jumps. So you can't take it to heart, but it's a fairly accurate thing of how and where your case is being processed.
I thought that when they pay this money, pay the fees and everything, they used to look at you as an urgent case, but I didn't know it's like that,
It is urgent. It is urgent in one sense, in that you would want to get it in as soon as possible, because what NVC's job is, their job is to gather all of this stuff from you.
Okay.
Okay, and they then package it. Once it's packaged, it sits there and it waits to go for your visa stuff to become available, your visa number to become available, and then it is sent off to the embassy for final processing.
Okay.
So the key is if it was in the National Visa Center and nobody supplied documents, or it's taken a while, those are things that cut time on processing.
Okay.
Right? So the key is to get everything as they ask for it, and so on.
Okay, thank you.
Sure, not a problem.
Have a good night.
All right.
Bye-bye.
Okay. We're going to go to a commercial break. Actually, I will take this call and then we'll go to a commercial break, and I will come back in and finish up with the deportation. Hello, good evening. turn your television set down, please?
Okay. Good night.
Good night.
I would like to find out. My husband is a green card holder, but he's in Guyana 4 years now. What he can do now because he wants to go back to the States?
Well, he has a major problem, and more than likely, he will be deemed to have abandoned his residency in the United States. You're only really allowed to stay out about 364 days per year. On the 365th day, you are deemed to, there is a presumption that you have abandoned your residency. Now, if it is that he has been out and has been out for circumstances beyond his control, he can explain that. He'll have to file an application, or in the way of heading back in, he's going to have a very good explanation for why he has been out for 4 years continuously.
Okay. But he can go carry in his green card and ask for a 10-year visa? They would,
that is something that a lot of people try to do. Right? A lot of people have tried to do that. It's nothing guaranteed. I mean, at this juncture, unless it is that he's had some serious medical issue that has had him laid out or whatever, don't think that because you had a green card means that you're eligible for a non-immigrant visa or visitor's visa. There's a lot of people who think that, and there's a lot of people who have problems getting that visa.
It didn't expire yet, you know.
I'm not worried about whether the green card has expired. Whether the green card itself has expired is irrelevant. Okay?
Okay.
He stayed out. He's a permanent resident. He has stayed out for more than 364 days without requesting prior permission, without requesting any extensions. More than likely, unless it is that he comes up with a real good excuse, he will be deemed to have abandoned his permanent residency.
Okay.
Okay? So I think that he needs to, if he wants to get back in and he really has no intention to live there, then that's fine. Just go, turn it in. Maybe if you want to make an application for a visitor's visa, you can. However, just know that there are certain things that are required to apply for it, and hopefully he satisfies that criterion. Who filed for him?
His daughter.
Okay, so if he ever wants to, if he, let's say, is deemed to have abandoned this permanent residency, then she could either refile for him, at which time it may take, if everything is done correctly, he can reacquire his permanent residency in about a 12-month period, or he can make an application for a visitor's visa. But worst case situation, he still has a route, as long as his daughter, who's a U.S. citizen, wishes to refile for him, then that can be done.
Okay, thank you.
Okay? Alrighty. Alright, we're going to take a quick commercial break, and we shall be right back. Would you like to live and work in the U.S.? Have any of you or your family members been denied your permanent resident visas from any embassy or consulate of the United States abroad? U.S. immigration attorneys licensed to practice in both state and federal courts in the United States and focusing on immigration law can help you. We handle applications for green cards, re-entry after deportations, waivers, U.S. embassy denials for fraud, misrepresentation, prior crimes, and any other reasons. We also handle appeals, advisory opinions, and deportation cases. We are the immigration attorneys for you. If you are married to a U.S. citizen or permanent resident, or the parent or child of a U.S. citizen, you may be eligible to adjust your status in the United States without having to leave the country, whether you are illegally in the U.S., out of status, or in any other precarious situation. For more information or an appointment, call Blackman and Melville, PC, at main number in our Manhattan, New York office, 718-576-1646. Georgia number, 770-222-8246. 8240. Or for our Caribbean offices, 225-2684 for Guyana and 876-665-3911 for Jamaica. If you have been denied your permanent resident visa and have been found to be inadmissible to the United States by any consulate or embassy, all is not necessarily lost. You may need to act quickly before you lose any of your lawful rights. Find out the procedures and understand what needs to be done. Blackman and Melville PC can assist you in working your way through these difficult tasks and help you obtain your permanent residency. For more information or an appointment, call Blackman and Melville PC. Main number in our Manhattan, New York office, 718-576-1646. Georgia number, 770-222-8240. Or for our Caribbean offices, 225-2684 for Guyana and 876-665-3911 for Jamaica. Yes, I'm sorry. I'm on the phone with a viewer who is asking a question. The answer to your question is I don't know how long you're going to have to wait, but even when he does get the citizenship, he still has to file for you, which means that that's roughly a 10-year. If you're over the age of 21, you're looking at roughly about a 10-year wait from the date that he files. Okay?
Okay, thank you.
All right, great. Bye-bye. Okay, we're in our last quarter of the program, and I do apologize that we haven't been able to cover much more stuff, but I was trying to take as many calls as I could during this segment. Hello, good evening.
Hello, good evening.
Good evening.
I'm calling to find out. I have a visa to visit the States. I was there for about a month. But I'm looking to make changes in my life. I wanted to know, is it possible for a person on a visitor visa for a period of 6 months, what are the criteria they'll have to look after in order to obtain a permit to work while they're there for the few months?
Okay. First, if you go on a visitor's visa,
Yes.
it is a violation of your visa to obtain employment. Okay? Now, we'll stick a pin right there. We all know people who have gone there on a visitor's visa and have worked.
Yes.
Okay? But what they're doing is unlawful. And they can get their visa revoked, canceled, and have any other number of penalties imposed upon them.
Okay.
And more than likely, you will never get a visa again.
Okay.
Okay? Now, what I suggest you to do is you need to look at your situation and assess whether it is that you have any qualified relatives, number one,
Yes.
who are willing to file for you. If you have a fiance can do it. If you have a spouse who's a U.S. citizen, they can do it. Other than that, it appears as though you want to work. I don't know what your background is, but you would have to have an assessment of that situation to see if maybe you may be eligible for a work visa, which is really what, if you really wanted to go there for work, you should be focusing on a work visa.
A work visa.
Right, but a work visa, you now need a sponsoring individual who is willing to file for you because you either possess certain skills that are not readily available, or any number of the OP, H-1B, H-1, H-class visas. You know, those are a whole different category of visas, and so on.
My work skill is a professional nurse.
You're a nurse?
Yes.
Well, that's like number one on the list. So what I think that you may want to do is, for you, you're probably one of the easiest people to get a work visa for, because of the shortage of healthcare professionals. and they are hiring healthcare professionals left, right, and center. So what I probably suggest that you might want to do is to start looking at those agencies that hire, those facilities that hire, and because they will have to sign off, even if you get there and let's say you get an offer, you'll end up having to do an adjustment of status. Even if you have to come back to Guyana to pick up the visa, it's pretty heavy paperwork. It's not your cut and dry, go fill out an application and walk into the embassy type thing.
Okay.
Okay? Alrighty. Great. Good luck. Okay. We're down to our last 10 minutes. So what we're going to do, I guess I'm going to take another call. Hello, good evening.
Good evening. My father became a U.S. citizen a couple of years ago, and he put in for us since 2013. However, I'm legally married with a child. How long would I have to wait until I get papers or hear anything?
Okay, you're over 21 and you're married.
Yes.
Were you married at the time when he filed?
Yes, I was.
Okay. Your situation, you're probably going to be looking at, I would say, in between a 10 to 12 year period. The way that things are being processed right now.
All right, thank you.
Okay, bye-bye. All right. Now, I'll try and see if I can get... All right. Hello, good evening.
Hello.
Hi, can you turn your television set down, please?
Hi, good evening.
Hi.
I'm just calling to find out, when the embassy sends you the first paper that your parents have filed for you, does the first paper matter?
It matters to give you notice, and it also contains your receipt number. Your receipt number is what you use to make reference on your case, and you can use that number to follow up online, or even in referencing your case if you happen to call in. But it's just a notice that they sent you that it's been filed and that we're processing it. So what you need to keep off of that is the receipt number, so that you will always have that up until the approval of the petition, because that's how you're going to reference your case.
Okay, so I won't have to use that when I go for the interview with the last. Okay.
No.
Okay.
Okay. It's going to be down there in your file, but that's not what, by that time, if you're being processed through the consulate in Guyana or the embassy in Guyana, you're going to, after the approval, you're going to be issued a GEO number. It's going to start with GEO and have a string of numbers after it.
Okay.
Okay?
Thank you.
Sure. Bye-bye. All right. So in finishing up with the deportation thing, after you get the NTA and you have the allegations, you either challenge the allegations or you leave the allegations how they are and you concede to them. What's important about this section is that there's many things that can be done. You can file a motion to dismiss, you can ask for prosecutorial discretion, you can even file challenges to the grounds of inadmissibility. Now let's just say, and as we were talking before about the drug cases or the gun charges, is that if it is that someone says that you are removable because this thing that you committed or this act that you committed, and we're just going off of criminal grounds, right? But if they say this act that you committed is an aggravated felony, then what happens is, a lot of the times is that a lot of these things are found out that they're not actually aggravated felonies, which means that if it's not an aggravated felony, that you will be eligible you can be eligible for cancellation of removal, you can even be eligible for voluntary departure, you can be eligible for withholding, you can be eligible for a number of things. Okay? So it's key to understand what it is that is actually happening. So when you just sit there, if you go unrepresented and you say, all right, judge, whatever it is, fine, I'll sign off, you've done yourself a disservice, not only now on two parts, you haven't assessed your case. You might not have had to have left. Okay? That's number one. Secondly, if it's deemed an aggravated felony and that goes into the record and into the system, that's what it is, then what happens is when you think that you're going to get slick, you get sent home, and under that thing that everyone says, oh, well, I can apply back in 5 years. Doesn't work that way. And a lot of people, a lot of you out there have run into now that problem because you waited your little 5 years and then you've attempted to have someone file for you, or you've gone into the embassy trying to seek another way of re-entering, and you found that you've been told that you're permanently barred, and then you come into the offices of other people, and offices like mine also, and you're waving this paper or you're stating what they said. The judge told me and they gave me this paper that said I can be back in within 5 years. All of that's good and proper. A lot of those things aren't even that accurate. But what you have now been deemed is inadmissible. And you may be permanently, or at least maybe with a 20-year bar, inadmissible, ineligible of re-entering the United States. Okay? So it's really key to kind of assess situations. It's really key to be able to assess situations so that you can affirmatively and properly make a right decision as far as how it is that you're proceeding in your case. Okay? Once it is, let's say if you're not eligible, or if you are not found to be an aggravated felon, then that means that you're eligible for a bond, and that you don't have to stay in jail, and that you can be outside, you can be with your family, you can be with your loved ones for that period of time. So you need to make a proper assessment rather than not doing anything, not getting a lawyer, not getting anyone to even review the situation. Find a way to, call someone from the prison. I know a lot of people, they don't have a lot of money, the commissary's low, their family may have abandoned them, things may look real bleak, but find some way, get into the library, read a book, find somebody in jail who knows about the immigration procedure. A lot of people become immigration experts, okay, in prison. So, just be weary about simply dismissing yourself and agreeing to removal. All right, I'm going to try and be on the air tomorrow night. If it is that I think I may have to fly out somewhere. But if I don't, I will be here, and I will quickly try to have a program on the reentry after deportation. Okay? But I still want to continue with the various forms of relief from deportation so that people are fully aware of what the situation is. All right? So give me, you can give me a call at any of the numbers on the screen in my office if it is that I'm there. You can make an appointment to come see me. Finally, we're receiving a lot of messages and a lot of complaints because there are obviously offices out there around and about Georgetown and a couple parts of the West Bank and so on, and the East Coast, for people who are being fooled to think that they are coming into my office, okay, or the representation is made that they work for us. Unless it is that you're coming into my office, unless I tell you where the office is, or unless you call, unless you see me or one of the people in my office, it's not my office. So be very, very, very wary. Unless you see my signature on your document, that's it. So when a lot of people have been finding out that it's not my office that they went to, and it's being represented that they were in my office, or that I represent them, or that my firm represents them, you need to think twice. So unless you get a card from me, you speak to me, or my partner, it's not my office. Okay? So just think twice. My office you will know my office when it is that you see it. Anyway, good luck, God bless, and good night. We will send you out with the commercials and closing. And you can, like I said, you can give us a call in any of the numbers on the screen. I normally will try to answer as many questions as I can. Okay, good night. Would you like to live and work in the U.S.? Have any of you or your family members been denied your permanent resident visas from any embassy or consulate of the United States abroad? U.S. immigration attorneys licensed to practice in both state and federal courts in the United States and focusing on immigration law can help you. We handle applications for green cards, re-entry after deportations, waivers, U.S. embassy denials for fraud, misrepresentation, prior crimes, and any other reasons. We also handle appeals, advisory opinions, and deportation cases. We are the immigration attorneys for you. If you are married to a U.S. citizen or permanent resident, or the parent or child of a U.S. citizen, you may be eligible to adjust your status in the United States without having to leave the country, whether you are illegally in the U.S., out of status, or in any other precarious situation. For more information or an appointment, call Blackman and Melville, PC at main number in our Manhattan, New York office, 718-576-1646. Georgia number, 770-222-8240. Or for our Caribbean offices, 225-2684 for Guyana and 876-665-3911 for Jamaica. If you have been denied your permanent resident visa and have been found to be inadmissible to the United States by any consulate or embassy, all is not necessarily lost. You may need to act quickly before you lose any of your lawful rights. Find out the procedures and understand what needs to be done. Blackman and Melville PC can assist you in working your way through these difficult tasks and help you obtain your permanent residency. For more information or an appointment, call Blackman and Melville PC. Main number in our Manhattan, New York office, 718-576-1646. Georgia number, 770-222-8240. Or for our Caribbean offices, 225-2684 for Guyana and 876-665-3911 for Jamaica.
Chasing a dream.